Good evening, everyone. Thank you for coming to region number 7 in collaboration with region number 2 and number 3 of the Regional Family Support Planning Council's presentation on person-centered planning. And I just want to start off by letting everyone know that we have a multilingual captioning app called Wordly. Jacinta will be sending you an invitation asking you to join. If you need any other language besides English, if you need Spanish, French, any of the above, please feel free to use it. If you do need English subtitling, please choose the closed captioning app at the bottom of your screen. Periodically throughout the presentation, you will see invitations. If you don't need it, just please click ignore. Otherwise, we're going to get the presentation started. I'll pass it off to Jen.
Good evening, everyone. Thank you so much for joining us as we present person-centered life planning, securing the future for people with disabilities. We're very excited to have our speakers here tonight and can't wait to get started. But just a couple of quick housekeeping pieces that I would like to go over with everyone before we get going. First of all, I know everybody's going to have a ton of questions. And so please feel free to use the Q&A section at the bottom of your screen. We are not using the chat for questions. So once again, there's a Q&A button at the bottom of your screen. Feel free to click on that and enter in any questions that you might have. Some of the answers to those questions will be posted during the presentation. We have someone who will be actively monitoring those questions and answering as many as possible. However, some questions may require a little bit more of a detailed answer, and we're going to hold off on answering those until we have our question and answer breaks. There will be a couple of break periods during the presentation where we can answer some of those burning questions that you have. And then at the end of the presentation, we're also going to have time for Q&A then. So please be patient if you don't see your answer. It is coming. And also please feel free to scroll through because your question may have already been answered. So just double check before you post anything, just to make sure that maybe some of those things are already included. And somebody else had the same question that you did. Copies of slides and handouts will be available tomorrow. Those are going to go out via email. So check the email for the account that you registered for this presentation under, and that's the email account that the slides and handouts will be going to. Also, at the end of the presentation, you will be sent a survey. It's a quick survey. We encourage all of you to please fill it out. It is incredibly helpful for us. It gives us really wonderful feedback on your thoughts about the presentation, lets our presenters know what they did great and what maybe we need to tweak a little bit. And it also lets us know how helpful you found this program so that we can better tailor our programming to you and to the interests that you have. Additionally, we have some presentation here on the screen. So I'd like to tell you a little bit about the Regional Family Support Planning Councils. There are 10 of them here in New Jersey. They were divided up by county. And it's a really wonderful opportunity for families and individuals with developmental disabilities to join in and be part of the advocacy. We meet regularly. We have monthly meetings with state leadership concerning issues that everyone is very concerned about. It's an opportunity for us to have those one-on-one discussions with leadership and really be a voice for change and advocate for that change. Additionally, we have monthly meetings. At each council has a monthly meeting, and it's a great opportunity for you to voice your concerns to the chair and to the council, so that we can again pass those concerns on and really have an opportunity to empower families and make sure that your voice is being heard. That's something that really makes us unique here with the Regional Family Support Planning Councils. And if you look at your screen now, you can see which region you might belong to. I'd like to take a moment here. Actually, Carrie, if you could just forward us on here to the next slide. Yeah, that we already covered. Oh, and we do have educational opportunities like tonight. We also have quarterly meetings as well. And you can also follow us on Facebook and Instagram and keep up. We try to post a lot of relevant issues as well as our educational and meeting opportunities. Then I'd like to go ahead and do introductions. My name is Jen Airy. I am one of the co-chairs for the Regional Family Support Planning Council Region 7, which is Burlington and Camden County. And I am the mom to two boys with autism. Their ages 21 and 18. And I'd like to introduce my co-chair, Laura Kelly. Laura, would you like to
Hi, everybody. Thanks for joining us this evening. We hope you find this very informative. I have a daughter, Alexa, who is 34 years old. Alexa is in self-direction. She is profoundly disabled, and this is what's working for her. She lives in her own apartment. So I will introduce John from Council 1.
And I am pleased to be joining, no, I'm Council 3. Sorry. That's Union and Somerset counties. I am the father of a delightful and charming 35-year-old young lady who is profoundly disabled, the principal symptoms being cerebral palsy and seizure disorder. She is the principal reason I'm here tonight.
Wonderful. And I'd also like to introduce Dottie.
Dottie is having some issues logging in at the moment, but
I'll go ahead and introduce her then. So Dottie Blakesley, she is the statewide co-chair for the Regional Family Support Planning Council, as well as the co-chair for Region 2, which is Bergen, Hudson, and Passaic counties. And she's the mom to a 31-year-old daughter with autism and epilepsy who recently moved into a group home. So some big transitions with her family as well. And so without further ado, I'd like to go ahead and introduce our presenters for tonight. We are very fortunate to be joined by Jason Miller. He is the Director of Social Services at Planned Lifetime Assistance Network of New Jersey, or Plan NJ. He's been there for more than 15 years, and he performs a full range of assistance to families of and individuals with developmental, physical, and mental disabilities, providing clients with services including court-appointed guardianship, case management, supportive counseling, and psychological assessments for intake. Jason also supports families with social service advocacy to navigate federal and state social service systems, and implements life planning services to guide families in effectively preparing and executing life plans for their family members with all types of disabilities. He's joined by Melanie, who is a social services manager at Plan NJ, and she'll be helping tonight with all of your burning questions. Take it away, Jason.
Okay. Thank you very much, and I appreciate it. All right, folks, let me pull up. All right. Well, thank you for joining tonight. So tonight we're gonna talk about a lot of different topics. We're gonna, the title of the presentation is Person-Centered Life Planning, right? And within that scope of that is there's a lot of different issues. So tonight's agenda, we're really going to talk about, life planning. What is life plan? What does it mean to create one? What are the ramifications of that? We're going to talk about guardianship and alternatives to guardianship. We're going to talk about special needs trusts, and we're going to talk about able accounts. And those are really kind of the pillars of kind of the background administrative services to things. So a little bit about Plan New Jersey. We're a statewide nonprofit organization. We were established back in 1988, much by an organization much like this one. A lot of families that had concerns of, okay, I have a finite lifespan. My child is going to outlive me. Who's going to be the person that's looking after that child when I'm no longer here? Sometimes families have a lot of depth and many members that can be actively involved, and then other families may only have a person or some none at all. So within the scope of what they were charged with, that kind of created what our mission was, which is answering that question of an organization that outlives any person. So I've been with the organization for now 16 years, a little over 16 years. And, this organization is going to far outlive me. And that's really what our founding purpose was to outlive any person per se. Some of the services we provide, and I'm going to just talk a little bit about this because tonight really is more about, the educational aspect of what are these things and what can you do in the background and in the short term to make sure that there's a good long-term plan in place. But part of the services that we do at Plan New Jersey are serving as trustee, serving as representative payee for folks that we're performing other services for. We do guardianship services. We actually do family support services. What that means really is maybe there's a sibling guardian, but they live out of state. Plan New Jersey will help them maintain their court obligation, a visitation and being in proximity, making sure a person has access to all the things that they need and that oversight, and then reporting that information back to that family guardian that maybe lives in, say, California, right? We do a lot of case management. That's really how we accomplish really all of these major tasks is by visiting at home, making sure that an individual has all the necessary things, making sure that you have a relationship with that person, what's going on, and this is probably something that resonates most with parents is who's going to be the keeper of information, who knows about that follow-up doctor's appointment that they have to get every 6 months or every 12 months. Really that is one of those things where, parents worry that, things are going to fall through the cracks and, things aren't going to get done. So a lot of it is that case management and making sure that, advocacy is in place to not only support when things are going well, but also support when things maybe aren't going so well. And then the other piece of things that usually is concerning to parents is who's going to manage that correspondence that comes in. Public benefits are an extraordinarily challenge to obtain. And then once you obtain them, there's ongoing documentation that you need to fill out, whether it's annually, whether it's every couple of years, but making sure that somebody's going to receive that correspondence, respond appropriately to it, provide the necessary documentation to make sure those benefits stay in force. So these are different things that we do for folks that are part of Plan New Jersey. All right. So when we talk about, sorry about this, guys. Okay. Floater on my screen. So when we talk about the beginning of planning, so regardless of what kind of services you need, so if whether you need a guardian, whether you need a power of attorney, whether you need a trustee or a representative payee, the biggest piece of all of this, because this is the one thing that connects everybody, is you need a plan. So and what a plan starts with is figuring out what a person needs, right? My needs are different than your needs, and they're different than the next person's needs, right? So when we start developing a life plan, the first part of figuring this out is what are the resources? What are the resources that are there, right? Who's going to, where's a person going to live? Where is a person going to go to school or work? Do they need to be near public transportation? Do they, what is the geography, right? Where is it that they're going to be, right? And then you also have, how are these things going to be funded? Who's going to, what kind of income is going to be there? What kind of benefits does a person receive? Do they have an ABLE account? Do they need a representative payee? Is a special needs trust appropriate? All of these kind of tying in to make sure that, that a person is surrounded by the things that they want, right? The idea is not to just put somebody and put them on a program and that's good enough, right? The idea of a life plan is to create a program around an individual, not fit somebody into a little box, right? So that said, once you kind of figure out what a person may need, what resources they may need. Do they need a guardian or do they need a healthcare proxy? It's a matter of starting to figure out who are the appropriate people to do that, right? So who's going to serve in legal roles, right? So you have different roles out there, right? So if you as mom and dad are already legal guardian, one of your jobs and one of the most important jobs as legal guardian is to select who the next person is going to serve in your absence, right? And what's that's called is called a successor guardian. Okay. Same with the financial role, right? So if you're in a position where you're paying for, dispersing funds on behalf of your child or brother or sister, you need to make sure that somebody is going to, again, be able to duplicate that role at a later date if you weren't there. And that extends out to representative payee or able accounts. And then the other, like I said in the previously was, the bigger piece of this is who's going to be advocating and making sure that information, stays with an individual, right? It's one thing for someone to go to a doctor, but what if a doctor gives you, a task, right? So, you go to the doctor and they say, okay, well, you need to follow up on this issue. Who's going to make sure that those kinds of things happen, right? Now, some of those things happen, within the DDD service system. Some of them happen within the health system, but an individual, may move from place to place. And one of the things there is that, there really should be a point person to ensure that information, continues to remain there. Making sure that if somebody has, some chronic condition that, it's treated, at ABC agency, but if they move to, XYZ agency, that they're still continuing to perform that treatment or follow up on that condition, right? So that's part of making that plan for those key people. All right. So I'm sure everybody's familiar with charting the life course documents. We love these tools. A lot of these slides that I'm gonna go through over the next few slides really are extraordinarily helpful when you're starting from scratch, right? A lot of times people just don't even know where to begin with writing a life plan, right? And identifying roles is usually a great place to start, because we all have things that we need, right? We all have things that we support. Not just supporting other people, but support we need ourselves, right? So when we break that out, we can kind of put it into a couple of different categories here, right? So on this slide, we talk about caring about versus caring for, right? So caring for someone is providing day-to-day responsibilities, making sure that somebody has, the necessities, make sure they have meals and transportation and, activities and things to do and facilitate relationships and things like that. And then you have, this other area, which is caring about, like who's going to remember someone's birthday, who's going to bring somebody gifts for the holidays, all the things that mom and dad or brother or sister would do, and who's going to provide that lifetime commitment, because an individual may be in an agency one day, but there may be circumstances that require someone to move. So you want to make sure that there's somebody involved that can keep that information with them, right? So and you guys are going to get these slides, I believe, tomorrow, would be my understanding. And these are great pieces of information that you can start to draw this out. Another exercise that we like to do as far as life planning is doing what's called a star map. And what a star map does is, it helps kind of, in this case, we have Connor in the center. It maps out like what are the things that are really important to Connor. What helps Connor, maintain, his lifestyle, do the things that he likes to do. So, if we start over at relationships, mom, dad, Lily, Peyton, these are all important people in his life. If you're moving around the star, what is Connor? What are Connor's strengths? He likes to make friends. He likes to laugh. He's smart. He's funny. And then how does Connor connect with other people, right? And one thing we learned, especially over the last several years, and namely we're on this presentation, right, is what technology exists to help connect Connor to his community, to his friends, to his relationships. Connor has an iPad, a cell phone, a laptop. He even has a microwave, so it helps him maintain some independence as far as making meals and things like that. And then community supports. He likes Boy Scouts and YMCA. And then finally, what is he eligible for, right? Because that's the dollars that help support that plan. So he's got Medicaid, he's on self-directed supports, he's got SSI. These are all pieces that help Connor live the life that he wants to live. Okay, and then this last slide, and the reason why I like having this up here is, we actually had our staff do this because it's really just a great exercise in, just looking at the trajectory of your life, because we all have things we want, and we all have things that we don't want, right? And a good example of that is, for me, I don't want to live in long-term care. That's just a big pet peeve of mine. I don't want to. That's not the life I want in the future, right? So I'm going to take the steps, both from past life experiences and current, to ensure, or to do my best effort to not end up in a situation that I don't want. And we can do that with pretty much anything. A good real life example is I talk to hundreds of families every year, and it's pretty split. I see one of the hot button issues of residing in a residential group home versus not residing in a residential group home. Some families are like, yeah, I want him to live in a facility because he's lived with us all these years, and I want him to make friends and isolated. And then there's other parents that say that I don't want him to be in that kind of congregant living, because there's the potential higher likelihood of abuse, or whatever it is that they've compiled as their reasoning. It doesn't even matter. The point is that this allows you to help create that vision for what you want for your loved one. All right. So I want to talk a little bit about legal guardianship, because I just think that it's a fair starting point that everybody understands what it is and what it isn't. Guardianship is not the end all be all. There's a lot of different things out there that you can, as far as tools to support an individual. But I think that the starting point of understanding what guardianship is, how you would obtain guardianship, is just an important starting point for everybody. All right. And then after this, we're going to talk about some alternatives to guardianship, because quite frankly, guardianship is not for everybody. Everybody doesn't need a guardian. So basically, at the age of 18, 12:01 a.m., an individual, regardless of whether they have a disability, do not, in the state of New Jersey, country at large, they become their own legal guardian. That's usually very scary to parents, especially for someone that may have a profound disability. And I want to just take a quick point to say that it is virtually impossible to have a court date scheduled on your 18th birthday. But I will tell you that it's really okay. So there's nothing magical that happens on someone's 18th birthday. It's really more of a legal formality that, that's the point at which you can apply to be a guardian, because prior to age 18, you already are the guardian. Okay, because if they're your minor child, ultimately you're guardian up until that point at 12:01 a.m. on the 18th birthday. Now, if something were to happen that required a guardian to intervene, or a medical procedure, the reality is that's typically going to default to next of kin. So guardianship on that birthday is not something to be scared about. And the reason why I'm saying it out loud over and over again is because a lot of people are very, very scared about that point in time. So let's assume that we have an individual. He's got profound disabilities. Maybe he's nonverbal, significant disabilities, and it's pretty clear and convincing. The parents would petition the court, okay, and what that is, it's a civil matter. It goes before the section of the court called the surrogate court. And what the surrogate court does, they manage not just adult guardianships, but they also manage wills and probates and that section of the law. Most people are familiar with, the civil court, criminal court, family court, things along those lines. This is kind of that lesser known court that manages some of these outside issues. So when it becomes clear, and after the 18th birthday, you can petition the court to propose yourself that a person is allegedly incapacitated, okay? And, like any other court process, you have to provide evidence that this person is incapacitated. The form of evidence that the court requires for this kind of a case is sworn affidavits from medical professionals. So you can have a primary care doctor, a psychologist, a neurologist, a psychiatrist, any doctor that has to do with the brain. I mean, you can't use a podiatrist or, a dentist or something like that, but specifically as long as you're working with a doctor that can do these kind of evaluations. And, one of the important things that people should recognize is, what they're evaluating is not whether you make good or bad decisions, because that's not what this is about. This is not about good versus bad decision making. This is about the way in which you come to a decision, your capacity to make it, to understand the ramifications of a decision. So once you have those affidavits, that's going to get presented to a judge, and then a judge, because that is the only person that can assign a guardian in the state of New Jersey or the country at large for that matter. Okay, so it's not mom or dad that decides, it's not a doctor that decides, it's not a friend that decides, it's only a judge that can say, yes, this person needs a guardian and who that guardian would be. The judge takes all that information in, takes all that evidence, reviews it, and then makes a determination. So we have in the state of New Jersey what's called the limited guardianship law, which means that, essentially the judge is only supposed to assign guardianship for the things that are necessary. And what that means is when we talk about the different types of guardianship, there's guardian of the person, okay, and guardian of the property. Property is kind of a misnomer because it doesn't mean just physical real estate property, but it actually means, whatever their assets are. So money in essence. So, so when you have a guardianship, it could be a limited guardianship, okay? It could be guardian of person or property, or it could be a guardian of both, which is also known as a plenary guardianship, meaning that you're a full guardian and you're responsible for all of those decisions, okay? So when we talk about, once that judge has reviewed that and they assign guardianship, let's say they assign guardianship and they assign it to mom and dad. The judge will sign off on that order, and mom and dad will get a certificate that says that they are legal guardian for their child. One of the duties of, one of the primary duties, and while it's not on here, one of the first things you need to do is start thinking about who would be a good successor guardian, right? When we talk about the qualifications for a guardian, the two primary qualifications are capable and willing, right? So, if those two things don't match up, then perhaps you don't have a good guardian. And the reason for the importance of selecting successor guardians is because, ultimately, you really need to be in a position where, you are able to assign who that next person is, because even if something does happen to you, the guardianship does not terminate. So what happens is in the instance where a family member has not been, so let's say mom and dad are guardian and they don't select a successor, what happens is that the guardianship doesn't go away. So the court has to then assign somebody, guardian, maybe somebody that mom and dad don't know. Maybe there's somebody that, I don't think that the court wouldn't assign necessarily somebody you wouldn't approve of necessarily, but a part of guardianship is you want to make sure that, someone is attending to your child in the way that you want them to, that's following that life plan, right? To make sure that, your child has, all of the advantages that you've been trying to provide for them. So other duties that you have as guardian, you have to visit, the statute says at least quarterly. That doesn't seem nearly enough, but the statute minimum says that you got to visit at least 4 times a year. We visit our folks that we're guardian for at least on a monthly basis, sometimes more frequently, depending on what that situation is. Just because it's very hard to help a person guide decision making, to help guide somebody's decisions if you're only meeting them a few times a year, right? Within those responsibilities are reporting to the court. When every year on the annual the month of the appointment, you're required to submit a report to the court indicating, that certain steps have been taken, that they've been to the doctor, that there's been no changes in health status or anything like that. So the court is responsible for overseeing those guardianships. It's also a misnomer out there that once you're the guardian that you don't answer to anybody. That's not really true. So really, whoever is guardian, even if you're mom and dad, you still have an obligation to report to the court, so the court knows that individual is being cared for. Other responsibilities is to promote self-determination, and what that really means is helping a person achieve the things they want. This, guardianship is not do as I say, do as I say, do as I say. Guardianship is, at least in our view, is breaking down barriers to ensure that an individual has the life that they want. Going back to life trajectory, right? The idea is that everybody's an individual, and they have the right to self-determination, right? This is what I want. And presuming that it's safe and, and it's not something that causes them likely harm, the guardian is really there to kind of help break down those barriers to get them to the space that they feel most comfortable. All right. And then the other part is part of the role as guardian is to help with revocation if necessary. And what revocation really means is return to capacity. And what that means is that, if somebody needs a guardian for a temporary period of time, and you see a lot of this with more so with folks with a traumatic brain injury, where maybe they need a guardian for a short period of time, but they go through the rehab steps and gradually get back to a space where they can, regain that capacity and go back to making decisions for themselves. All right. So alternatives to guardianship. So like I said, guardianship is not the only thing that's out there, right? It's not an all or none proposition, right? So there's other tools that can help when maybe guardianship isn't appropriate. And I can't even go through the list of reasons, that it wouldn't be appropriate. There's tons of them, right? So guardianship being, the most restrictive, presumably, that you would say is oversight over an individual. There's other supportive roles that you can take. So, in many cases, a power of attorney or a healthcare proxy is absolutely sufficient. One thing to note that, power of attorney and healthcare proxy, power of attorney is a little bit more broad. Healthcare proxy is just for healthcare decision-making, as the name indicates. Power of attorney would also allow you to provide some banking services and possibly, just provide more general, guidance for an individual, maybe interface with other, financial institutions as well as healthcare institutions. So the big thing with power of attorney, they're a lot easier to get. When we talk about guardianship is a court appearance required situation. Especially for an initial guardianship, a judge has to make a ruling and say, yes, this person is incapacitated, and beyond that, who is the most appropriate guardian? Or a power of attorney is really someone giving you permission to act on their behalf, right? That you could open up a bank account on their behalf. You could, talk to an insurance company on their behalf. You could, do a lot of different things at the request of the individual. So, the other piece of that is like I said, no court involvement. This is something that can be done at an attorney's office, in an afternoon to go sign papers, saying that, my mom or dad is going to be my power of attorney, right? So the limitation on powers of attorney, and this is important, is that it is completely and totally verbally revocable. Whereas a guardianship would need a judge's order to undo a guardianship. A power of attorney just needs the individual to say, I don't want you to be my power of attorney anymore. And that's it. It's entirely revocable. But why that matters is when we talk about, the mental health system, a lot of times parents might be the power of attorney and they're trying to get information about their child. They may call a hospital and say, hi, I'm so-and-so's mother. I'm the power of attorney. Can I get information on John, let's say? And they're still going to have to ask John if it's okay to release information. If John says no, well, the mom and dad can't have that information. Power of attorney does not give you, really that same level of authority of a guardianship. Another thing to take care of, as far as, not an alternative to guardianship would be, representative pay for Social Security benefits. So, if an individual is potentially there for exploitation, just ripe for exploitation, perhaps a representative payee in place, maybe not a guardian, but just a rep payee to control the money, to make sure that the rent gets paid, that, these different things get taken care of financially, and no one can come in and say, hey, can I have $100, or, be manipulated into, having that money taken from them. And the same holds true for a trustee of a special needs trust, which we're going to get to in a little bit. We're going to talk about all the different types of trusts, but similar thing. That's not necessarily that. It's not federal money in a trust, but it's either the individual's money in by way of a first party trust, or it's mom and dad's money that they've left to them from their estate, that needs management and obviously needs that same level of protection. Okay. All right. So I'm going to take down some slides here. And I think we could take some questions.
So Jason, we have 5 different questions right now in the Q&A.
Sound good?
First question. If you are the guardian of a developmentally disabled individual, can that individual's ABLE account be used to pay the filing fee for the yearly surrogate court reports that need to be submitted?
I would imagine so. So it's really, I mean, an ABLE account can be utilized for anything related to an individual's disability. There's a very wide array that you can use it for. You would just need to keep receipts, but absolutely, I can't see a reason why they wouldn't allow that.
Okay. Next question. What does one do if they know their 32-year-old needs support and a plan, but he will not agree to any of this? Does this mean I need to get a limited guardianship, or is there another approach?
Can you get that one more time, Melanie? There was a little bit of a crackle.
Oh, I'm sorry. It says, what does one do if they know their 32-year-old needs support and a plan, but he will not agree to any of this? Does this mean I need to get a limited guardianship, or is there another approach?
So that's a very difficult situation. So if an individual does not is contesting the idea that they need support, you could be in for a very large battle. So one thing that I didn't get into, because there's a lot of information on the guardianship side, it is very, very difficult to become someone's guardian if they don't want you. And the reason for that is they have every right to their own representation. So actually an attorney is appointed for the individual, for the alleged incapacitated during that process. So what you could be buckling in for is a very difficult and expensive court battle to obtain guardianship. And the way I look at that is maybe there is a different way. You know, if you know, maybe you can have that trustee or that representative pay, because even if you win, you know, if you have to square off with your child, it's going to potentially do some damage to the relationship, because you're going to be providing factual information to the court. And even if you're right, your child is going to hear it. So there's no real way to kind of, you know, get around the idea that the person says, I don't want a guardian.
Okay. Next question. Do I need to hire a lawyer in order to get guardianship, or is this a process that I can do myself?
So actually, both are true. I would highly recommend, if the resources are there, to hire an attorney. There are deadlines involved. There are certain, you know, certain time parameters. So like when you get these affidavits, you have to meet certain deadlines. Some courts want it within 30 days. Some courts want it within 60 days. Some are fine if it's 6 months. You know, when you're hiring an attorney, what you're doing is having someone else manage those deadlines. You know, because if you don't meet them, they could effectively, you know, not hear the case, and you know, it's not going to help your situation. Alternatively, you can do this. It's called pro se. You can reach out directly to the surrogate's office and explain what your situation is and what you're trying to do. And at that point, they, you know, and it depends on which vicinage you're in. The reason being is because higher populated counties may have a little bit more difficulty providing you help and guidance, because they have a high volume of court cases. So if you're in Essex County, you might experience a little bit more difficulty getting help with that pro se process, or even, you know, Mercer County, just because there's just so many people in those counties. But if you went out to, say, Hunterdon County or Sussex County or maybe Cumberland County, you might get a little bit more ability to get a hold of someone. So you could do it pro se. I would highly recommend that you do utilize legal services for that, just because it is a very complicated process to get through that hearing and meet all those deadlines.
Okay, next question. If Plan New Jersey or someone else is the guardian of our adult son, are you paid for that role? How much and how are you paid?
Sure. So we are fee for service. So we actually do get paid out of the special needs trust. So parents typically will, you know, have that expectation that we're going to be drawing those funds out of that special needs trust. It's not stuff that you pay for now. You know, it's something that you kind of work into your estate plan. Typical guardianship services run between about $3,000 to $5,000 a year. You know, and the reason for that range is because I have absolutely no idea what's going to happen, right? You know, I don't know if there's a medical crisis or a psychiatric crisis. If all things are are going fine, and I'm visiting monthly, and everybody's happy. You know, your child is well cared for. It's going to be on the much lower end of that range. If it's a situation where a person has, you know, a psychiatric crisis where I need to intervene, so just like you as mom and dad, you'd be down there more frequently, paying it, you know, going to the hospital, working with doctors, making sure that things were okay, you'd probably be at the higher end.
Okay, and as a follow-up to that question, essentially the same for rep payee. If Plan New Jersey or someone serves as a rep payee, is that agency or individual paid for that service, and how much?
We are not. We actually do not take any fee for representative pay. So that's just something it's just counter to our mission. You know, ultimately, Social Security is really all a lot of our individuals have as far as regular monthly income. We've never been comfortable with taking whatever percentage they allow us to take. So that's just not something we charge for.
Okay. Can the current guardian assign the new guardian? And can you have more than one guardian?
Yes. So the answer is yes to both of those. So in fact, when you are a guardian, you want to pick who your successors are. So, you know, when you pick them, you number them in order. So if it's your brother now, because your brother's the same age, and if something happened to you in the short term, your brother's a good candidate for the short term. But you also need to think longer term. You need to think younger and your child's age, because you want to have somebody with the same generational life expectancy, right? So you would actually number them out in your will of who your successor is. So let's say it's your brother first, then it's your other adult son or daughter second, and then perhaps maybe one of their spouses. You know, so there's a lot of different options that you have in terms of that. So yeah, and the second part of that question, Melanie, was what?
Can you have more than one guardian?
You can, and what that's called is co-guardian. So what that means is that two people are serving as guardian. Now, one would think that both people would need to be in agreement in a co-guardianship to provide services, but that's actually not true. So when you're co-guardian, all members that are co-guardians have equal ability to assist with decision making for that individual.
Okay, and just a follow-up to that, what do we do if we have nobody to choose for a successor guardian?
That's when you would want to call us, because, you know, the reality is you should have some hand in knowing who's going to be looking after your child, because by not dealing with it, not selecting someone, really what you're doing is you're allowing someone else to make that decision for you. Because like I said before, if you don't make a decision and you don't select someone, the court is going to have to make that decision for you. So if that guardianship is in place and it needs to be there because that person meets criteria to need a guardian, the court is going to select who they've deemed as appropriate to be that guardian. And that could be a community agency, it could be an attorney, you know, it could be a lot of different folks. You know, could be the state. You know, there's a lot of different options, but I'm a believer. I like to make decisions for my kids right now. You know, I think that it's important, and you know, I would like to say that if, you know, I would want to know who's going to have a fair amount of influence on their life moving forward. So I think it's just something that you would want to ensure that you have a hand in. So, and one thing that, you know, I didn't cover earlier on today, you know, I know that it's going to be hard to get into like really specific questions, like specific personal questions. I did want to make sure that everybody understands that, you know, this is the start of a conversation. If you guys have specific questions, you know, we really would like you to give us a call. You know, you'll speak with Melanie first, and then you'll speak with me, you know, for an hour or two, just talking about making sure that you guys are well planned. There's no charge for that. You know, the reason why we do this is, you know, there's not really a go-to hub to get all the information you need on this topic. So that's why we do these seminars. You know, we want to make sure that there's a level playing field, because some people have information and other people don't. So we offer that. We'll take as long as it is, even if you're not planning with us or not doing anything with us. I'd really still like to have a conversation with you, so this way we can make sure that you're well planned and maybe at least troubleshoot some ideas, you know, troubleshoot some problems that you may be having right now.
Okay, just following up with successor guardianship. Does the
Sure.
court have to approve a successor guardian? So if someone names a successor in their will, does
Mhm.
the court recognize that assignment? Or will they have to determine whether that person is appropriate?
Sure. And what that's called is the qualification process. So you can, so if you select a guardian, let's say you selected Plan New Jersey, right? As a future guardian, I'm going to still have to go to court, and I'm going to have to take my oath that I will serve as this individual's guardian until I'm relieved by the court. And the reason for that is because you need to make sure that somebody is accountable in the future. So what the court does is they provide this qualification process that checks, the background of an individual. So, if I have a significant gambling problem and, $300,000 worth of debt, perhaps they may be a little bit hesitant to give me, guardianship for someone, who has a $500,000 trust, because that would be very tempting. So the person that you're selecting will have to go through that qualification process. It's not nearly as intense as completing, the initial guardianship and going through that process. But, you have to make sure that, someone can go in there and, take that oath saying that they will serve in that capacity until they are relieved by the court. And the court will relieve them if they have a legitimate reason. So like, let's say you selected somebody as guardian, but they get, bad news from a doctor 3 or 4 years later and can't really manage their responsibilities. They can go to the court and say, hey, I know I'm supposed to do this, but I really can't. I have my own health issues. So can we find somebody else to do this? Okay.
Okay, I have a few more questions. So are there any funds outside of family savings to pay Plan New Jersey to become a guardian? What if a family cannot afford that service for their child's lifetime?
Sure. So there's a whole lot of different ways that you can fund a trust. So this isn't like you don't set an account aside, like a family account aside. What you're doing is you're creating a special needs trust, right? And there's a ton of ways to fund a trust. So you can fund it with your estate. My favorite way to fund it, especially if resources are an issue, is a term life insurance policy. By getting a term life insurance policy, you can make the trust the beneficiary, and there's funds there for your child. You can usually get a no medical exam one or a medical exam one and fund that trust, because you can make a life insurance policy beneficiary anybody or an entity. So like a trust would be a great place to put a life insurance policy. But the longer answer to that question is if you do your level best and you're putting funds into the account, I can't promise that I can serve as guardian if there's no resources. But if there's sufficient to be close enough to make it throughout life, and if they ran out of money, we don't discharge people for running out of money. So they just become pro bono clients. So we have about 9 people that we're doing pro bono services for. So they have no resources. We just continue doing guardianship. I find that to be cool and unusual to be guardian for someone for 20 plus years and then say, oh, sorry, you ran out of money, so now you can't be anymore. So we're going to have to transfer you to the Office of the Public Guardian. That's not okay. That's not the right thing to do. No one should do that. So we don't. So we'll just continue to serve. And the way we fund that is through, being a private nonprofit organization. We're able to, utilize some grant funding. We have a charitable remainder trust, different things that we do that we can continue to perpetuate that promise, because we don't break promises. So if we tell a parent that we're going to provide guardianship services for someone's lifetime, we will continue to meet that regardless of whether they have funds or not.
Okay. And this question kind of follows that up. It says, if Plan New Jersey is only paid when a special needs trust is set up, who pays the majority of your organization's cost? Is it the state of New Jersey? Is there a possibility of Plan New Jersey ever being discontinued?
So that's a very big question.
Yes.
The answer is no. We don't get any state funding. So we actually do not utilize state funding. It would be a little strange, advocacy wise, for us to be getting state funding and then, advocating, because sometimes we have to advocate, with state entities. So that doesn't make a lot of sense. So we, our fees are generated. So the way we, manage our budget is we have, current trusts and current guardianships that fund our services. We're very conservative. We don't all drive BMWs. We are a nonprofit through and through. So, at the end of the day, it's, we make enough that we can survive just fine. We're a conservative organization. We do have a lot of assets under management. So that helps. So on the trust services side, that helps fund a lot of our social services. It helps fund our pro bono cases. Because one aspect of our pro bono is working with clients that have run out of money, and we will continue to be their guardian, but we also do a lot of transition services. So folks that are 18 to 21, they're starting to get involved in the adult system of care and exiting the children's system of care. So we do a lot of pro bono work helping families kind of manage that transition. Because again, when we get into, what we're doing here tonight, which is, just the information sharing, that, there's not like a flyer that you get on one page that says, okay, do step 1, 2, 3, 4, and 5, and you're good. So we help a lot of families just kind of manage, the difficulties of getting into the adult system of care and finding, kind of tracking that person, what kind of day programming or vocational services are there. Are residential services going to happen, in the short term, or is it something that has to wait? So, we do a lot of services there. So, ultimately the answer to your question is we are self-sustaining through our fees, as well as, our grant funding.
Okay. Can you talk a little bit about the court reporting? It says, I've been a guardian for 18 years and never knew about the requirement to report to the court annually.
And I'm not laughing at that question, but I did every time. So no, there is no entity of the state of law enforcement that is going to come around and slap handcuffs on you. So it's supposed to be in every order. I will tell you that they really don't worry too much about mom and dad. I mean, I can't endorse not doing the reports, but the presumption is that it's mom and dad. Maybe they're not as apt to send you a letter. I will tell you that our organization, for the folks that we're guardian for about 50 individuals. We'll get a letter if we don't send one on time. So we have our tracking systems because we have so many folks that those reports go out in a timely fashion. But in essence, if you started filling them out, they'll be happy to have. The court reporting is really, there is an initiative several years ago that they hire volunteers to actually read these reports. And a lot of it was because there was probably some bad actors that maybe did some things with assets that were inappropriate, whether it's disposing of assets, selling property when they weren't entitled to, and enriching themselves as opposed to, utilizing the funds for the individual. So there was an initiative several years ago that really kind of tried to streamline that process, but it's a volunteer process, meaning that, they have volunteers in each county that are supposed to review those reports. I don't work for the state of New Jersey, so I don't know what their progress is on that. I will say that, that they do, when we send them in, they do confirm that they've, received them. We don't get a lot of feedback. But like I said, if you started doing them, there would be no repercussions for it. It's not like they would say, well, where have you been for the last 18 years? I don't think it would be that kind of situation. Any others?
Okay, we have a few more.
All right.
This is a lively crowd.
We're gonna have 5 more minutes, and then I want to make sure that I get enough trust information in.
Okay. Can you discuss assisted decision-making as an alternative to guardianship?
I'm sorry, what was that?
Can you discuss assisted decision-making as an alternative to guardianship?
So this is a big question, and I'm probably not the best person to answer this yet. And the reason why is because there's actually a lot of work groups going around right now that, are really promoting, supported decision-making as opposed to guardianship. you know, one of the things that's out there right now is, you know, there's not a statute, right? So the idea of supported decision-making is really the way to go. I mean, there shouldn't be anybody that makes decisions for someone else. That's not a great system, right? You know, right now, you know, the only thing that we have the statute for is guardianship. And I know that there are, you know, entities, you know, really working hard and diligently to try and, you know, get some documentation so a statute can be created for supported decision making. Because really that is the gold standard. It's not I'm making the decision for you. I'm just going to support you in what you want to do. In the meantime, we're left with the idea of approaching guardianship in that same way. You know, we don't guardian with a hammer, right? We don't say you do this because I'm the guardian and that's what I said and that's what we're going to do. You know, we really drive the culture of, okay, I'm here in service. I'm serving as guardian. I'm not the guardian. I'm serving as your guardian. I'm serving you, helping you break down the barriers that you have that make life or work or whatever inaccessible. So my job is to make it as accessible as it can be to you, given where you're at. So that's where we're at with that.
Okay. Can you talk a little bit about the qualifications of Plan New Jersey staff?
Sure. Minimum requirements, we have bachelor degrees. Staff, we have several staff that have master's degrees. Some are licensed. I'm not a lawyer. I'm a licensed professional counselor. So, you know, so standard employment screenings, background checks, you know, ensuring that individuals, you know, are appropriate. But a lot of what we do is making sure that aside from those things, you know, making sure that someone has those minimum education requirements. Everybody's an expert in one area or another, or several areas. You know, so my background came from residential services. Many years ago, I worked in residential services with the DDD population. We have another person on our staff that's worked in the mental health sector, is also a certified housing navigator, because these are the things that come up in our world. You know, I mean, there's a housing crisis, so we need to, you know, we have experts that can help, you know, break down those barriers to get somebody into a home. You know, and people don't think that is a difficult thing, but it absolutely can be when you have limited resources, you know, and, you know, 200 people vying for, you know, 5 spots. So.
Okay. And let's see here. I'm sorry.
No, it's okay.
So if a parent wanted to have a plan with Plan New Jersey for their child,
Sure.
and the parent is the guardian, but the child refuses to participate with Plan New Jersey, do you still continue to accept him and try to provide what he needs, even if that child is not accepting of the service you're providing or the support?
I mean, that's complicated for this forum. I mean, I would say give me a call and we can talk about it, because there's different ways that you can introduce what our services are. It doesn't have to be, well, these people that you don't know, they're going to become your guardian. I don't know that I would readily agree to that either, right? You know, I think that's a human concern thing there. I don't necessarily see that as necessarily a barrier. I think that when you start putting faces and names to things, I think it helps. That's just a scary situation for anybody to say, you know, oh, sure, I'm happy to have Plan New Jersey serve as my guardian, whom I've never met. So what I would say is we could have a conversation about it and see if there is the ability to kind of, you know, shift that perspective maybe a little bit.
Okay. There are a few more questions that are in the chat. I'm going to respond to them.
Okay.
I'm going to type response to them if you wanted to go ahead and move forward.
Yes, I would. All right, folks. let's talk about special needs trusts. So the way a special needs trust works, all right, is it's a place that protects funds from the resource limit. Okay, so back in the 80s, they came up with a resource limit for both SSI and Medicaid, right? For SSI. And that resource limit is $2,000. So if you have more than $2,000 of resources, and we're going to talk about it in terms of SSI because there's about 50 different ways that this could go. So for the purposes of this explanation, we're going to talk about SSI. SSD is very, very similar. So if your child has SSD or even SSA, retirement benefits from you, it's still very similar, right on point. But I'm going to keep referring to SSI just because it's a little bit, it's just a little bit easier for explanation wise. So you have that $2,000 resource limit for both SSI and for Medicaid. Okay, if you go over that resource limit, you are effectively ineligible for Medicaid services. Okay, so if you need any type of care, like a residential home, a day program, any of those things, you need Medicaid to pay for those services because, they could be for a day program, $400 or $500 a day. For a residential program, it could be $150,000 to $250,000 a year. So without DDD services, right, and DDD gets a lot of their funding from state and federal Medicaid program, right? If you're above that resource limit and ineligible for Medicaid, that makes it very difficult for you to continue to receive those services. And in fact, if you're really above those marks, you're going to be kicked off of Medicaid, meaning that you will not be eligible for those services, right? So what I'd like to do is give an example of Tom and Sally. So mom and dad have two children, Tom and Sally. Sally's neurotypical. Mom and dad have an estate. They pass away, and let's say they have $200,000 after they sell their house and life insurance policies and things like that. So their will is split two ways, 50-50. Sally gets $100,000, Tom gets $100,000. Tom is on SSI and lives in a residential group. Okay, so that scenario, $200,000 assets, they pass away. Sally gets $100,000. She says, thank you very much, takes her money. There's no impact to her because she's not on any public benefits. Tom, on the other hand, Tom gets $100,000. He's now what's considered over-resourced, okay? So he has two options. He can either spend down the funds, okay, and until he gets below $2,000 and private pay for his services, or he can have his money in a special needs trust. Now, in Tom's case, if mom and dad did no planning, Tom or his representative would have to take that money and put it into what's called a first party special needs trust. Okay, and what a first party special needs trust means is that Tom's money, okay, he now owns the money because he inherited it the moment his parents passed away. It's not when they do the taxes, it's not when they finalize the tally numbers, and it's certainly not when he receives the check. The moment mom and dad pass, he is the direct inheritant of 50% of their estate. So Tom's representative is gonna have to take that money and put his money into a first party trust. And we're gonna get to that in a second. So now, same scenario, Tom and Sally, mom and dad pass away, $200,000 in assets. They each get 50%. Sally, same situation. She takes her $100,000. Thank you very much. Instead of the money going to Tom, mom and dad had created a special needs trust, okay? And instead of the money going to him, it's going to the 2023 trust for the benefit of Tom, okay? And because his parents did that, he has no impact on his Medicaid, no impact on his SSI, no impact on his residential status. Nothing needs to happen, okay? So in the instance, at that point, okay, Tom doesn't actually physically hold any money because that's what creating a trust is. It's putting a person or entity, if you will, between the direct access of that money. So Tom doesn't have direct access to the money, but Tom can ask for things, or his guardian can say, well, Tom needs new clothes, or Tom needs a vacation, or Tom needs transportation, or whatever it is, and that trustee will pay for any of Tom's needs, okay? So ideally, if you listen to nothing of what I say, you want to have a third-party special needs trust to have your assets go to instead of your child that's on public benefit. Because if you don't, what happens is Tom now has to create that first party trust. So he has to spend the money anyway, because it's not feasible for him to spend down the $100,000 until he gets below the resource limit and then go back on Medicaid. That's not very reasonable. So Tom has to create a first party trust. Now, the big difference here is that you're spending the money anyway if you have to create a trust. If you do it before you pass away, there is no Medicaid lien on them. If you wait until Tom gets it and a first party trust is created, now you now have a Medicaid payback provision. Okay. So there's an idea out there that Medicaid is insurance. Medicaid is not traditional insurance. So like Medicare is insurance, right? We all pay into that system. We paid into it for years and years and years and years and years. And then when we get to an age or we become disabled, Medicare is there to provide that insurance, and they cover 80% and you're responsible for 20%. Medicaid is not actually insurance. Medicaid is actually a lien. And what that means it does not mean that, because you've accrued this lien, they're going to come and take all your money while you're alive. What it means is that when you have a Medicaid lien, so let's go back to that first scenario where Tom didn't have a trust put in place and he created a first party trust. When Tom passes away, whatever money is left there, Medicaid has first right of recovery. Okay, meaning that if Tom has utilized Medicaid services over his lifetime, there's an account number attached to him. It's attached to it. There's an account number, his social security number. There is a number that Medicaid has paid out on Tom's behalf. And if Tom has any money left over when he passed away, Medicaid gets to recover those funds. So the reason why I say a third party trust is the better option is because Medicaid does not have that right when you put it into a third party trust as opposed to a first party trust, because those are your funds. You could direct them anyway. Okay, so you could give Tom money or not give Tom money, but the fact remains that it's your funds, not commingled with Tom's. Okay, so if nothing else you take from my conversation today, you want to start looking into that third party trust, because it's a way to protect assets and give those assets a long life. And beyond that, if you have multiple children, instead of that money going back to the state of New Jersey, in that first party trust scenario, that money actually goes to your other child. You can set up your other child as a remainder or beneficiary to your trust. So let's say, you recognize that your one child may have a higher level of needs. So maybe you put $200,000 in Tom's trust and maybe $100,000 in given to Sally. And then Sally is the remainder of monies if Tom does not expend it, right? So it gives you a lot more options because the money is never become Tom's property. Okay. So the other thing people ask is, well, why even do that? Why not just give the money to Sally, right? Sally promises she'll take care of Tom, which is fine, and you have every right to do that. But I will say, there's a reason that this exists. And part of that reason is for two reasons. One, maybe Sally doesn't take care of Tom and Tom doesn't get the things that he needs, right? The other thing is that if you give all of the money to Sally, right? And let's say Sally's married and she's happily married, and then one day she's not happily married anymore. They get divorced. Now her spouse has half of those funds, so, there's a lot of things that could go wrong in that kind of planning structure. And a third party trust makes sure that Tom has the benefit of those monies throughout the entire duration of his lifetime. And then when Tom passes away, if he predeceases, Sally, it can make her the remainder of the additional funds. So, it is the single most foolproof way to ensure that, there's funds available for Tom for the longest possible period of time, and then potentially some additional remainders. So I know I'm going to get the question of how much it costs to create a trust. There's a couple answers to that. If you do a private trust, it could be several $1,000s depending on what kind of legal services you're getting at the time. But it should not be more than a few $1,000s, presumably. Usually if you do it in conjunction with your will, you can kind of package that up and maybe reduce some costs for yourself by doing both at the same time. The other option, which is one thing that we have, we operate what's called a pooled trust, which is, you know, something that can be operated by a nonprofit organization. So this is a trust that does not cost any funds up front to join it. So you don't have that initial cost to write a private trust, right? But there are some caveats to this. So this is not the product for everybody. I just want to be very clear. If you are considering doing something like this, we need to have a longer conversation, because I want to make sure that you understand all the terms. You know, but basically the short of way a pooled trust works is, you know, you get relatively smaller amounts of money and you pool them together, okay, and then they get invested and you get a higher premium on it. So, you know, if you invest $50,000, you're only going to have access to some financial products, right, that are appropriate. I think we have about 15 or $20 million in our pooled trust. So when you pool $20 million together, you get access to better investment products, and that's the benefit of being in that pooled trust system. Is, you know, it unlocks that ability, and then what happens is depending on how much money you have, you get your prorated share of income from whatever those investments are. Okay. So this is what I definitely want you guys to have when you get the slides. This is a great breakdown. I know it's pretty thick. I'm hoping I explained it well, but it basically kind of talks about what the different types of trusts are. So because you have both in both programs, but really what you want to avoid are these self-settled trusts. You want to take action, you know, now versus, you know, when it's too late, because you can't write a third-party trust after you've already passed. So this is one of those things that you write. And then the other thing people ask me is, well, a trust is money, right? And I don't have money to put in a trust. The reality is a trust is not money. A trust is instructions on how money is to be spent or protected, right? So you can create a trust and have $0 in it. And in fact, I'd actually recommend that you do that. Part of the reason is that, you know, that trusts, if you fund a trust in advance, you have to pay tax on any income in there. And you're going to pay a higher income tax, likely a higher income tax on a trust than you would in your own personal income tax. You know, the idea is not to, you know, give our children our money and then eat cat food in retirement. The idea is to give them what's left over, you know, after we've, you know, saved and recognized what those challenges might be in the future. Okay. All right. So what can a trust pay for? So a trust can pretty much pay for anything other than food and shelter. And shelter is even questionable, because if you use a trust for shelter, you can take an in-kind support reduction. So in essence, trust can pay for a lot of things. All right. So really a lot of things like Medicaid and Medicare that aren't covered, right? So a great example is wheelchairs. They'll give you like a wheelchair every 3 to 5 years. If your wheelchair breaks before then, what do? Do you just keep wheeling around in the chair that's broken, or can you replace it? So that's something that can be covered. Tuition, books, cars, insurances, funeral arrangements, you know, cell phones. We have, this is a necessity. I know everybody has one sitting right next to them as well. But that's something that can be paid out of a trust, you know, because it's still not considered, it's not a necessity like food and shelter, right? And the reason why they have that kind of distinction with food and shelter is because that's what Social Security is supposed to be paying. Okay, so they don't typically allow it. It's really never food. You know, trusts do not pay for food. All right, so what you typically try and do is shift money around in the budget to pay for things that the trust can pay, that then that maximizes how much Social Security a person has left over to help pay their ongoing monthly things. You can have a house inside of a trust. If you want to do that, again, I would want to have a conversation with you, because you got to make sure that the trust is funded enough that you don't create a situation where, you know, the cost of the housing and, you know, and all the repairs and maintenance and things like that draw on the trust so much that, you know, that it becomes more burdensome to have the property. Clothing, any seasonal clothing, you know, the list goes on and on, you know. All right. And the other thing I wanted to talk about are ABLE accounts. ABLE accounts are a great tool. I see the Achieving Better Life experience of 2014. New Jersey didn't legislate this till a couple of years ago. well, a few years ago, a little before COVID started. What this is this is a savings account. Okay, so when we talked about that resource limit of $2,000, what the ABLE account allows someone to do is take some of their money and put it into an ABLE account. I think it's $17,000 a year. This goes up a little bit each year, where they increase the amount you can put in there. And what you're allowed to do is, let's say, you're coming up at the end of the month and you got $1,500 in your account and you got another $1,000 on the way on the first of the month. You can take money and move it over into the ABLE account up to a maximum contribution limit of $17,000. Okay. So I see these very large numbers on here of $100,000. I have not seen an ABLE account with that amount in it. I do not recommend it. There's better products than an ABLE account to have $100,000 sitting in. And that would be either a self-settled trust, or like I said, I haven't seen it, so I really can't speak to it. But in essence, you can continue to have your benefits, and once you hit that $100,000 threshold, they'll turn off your SSI, but you'll continue to keep to receive Medicaid. So again, I don't see the value in keeping that in there when ultimately you could put the money into a first party special needs trust and it would be better protected in general. So criteria for an ABLE account, just disability onset prior to age 26, and you can only have one ABLE account. As far as flexibility of spending, you can spend this on a lot of things. It's really, you really can spend it on just about anything related to a disability. And that could mean it could even mean groceries. Like if you have a medical condition that requires you to buy, gluten-free groceries, you could use it for that. So it's really anything that's related to your disability. More importantly, this is not a substitute for a trust. Okay. And the reason why is because this is a great place for an individual's money. This is a terrible place for parent money. And the reason why is because, like we said before, upon death, Medicaid gets repaid out of the account balance. So what effectively you're doing when you're creating an ABLE account is you're creating a first party trust agreement with the state, meaning that if an individual has a Medicaid lien and they have funds in their ABLE account, Medicaid has first right of recovery for those funds. And I'm okay with it if it's the individual's money, but there's better products for you as mom and dad that are going to prevent you from having to pay back a Medicaid lien that you're really not required to pay back. All right. And that's why you gotta, you really want to make sure that you're well planned, that you speak with an attorney, you speak with your financial advisor. In the absence of those two, I'm happy to have a conversation with you, to just talk about any of these issues, because we just want to make sure that you have, accurate information and can be as well planned as you can be. All right. So this is our contact info. And again, you guys are going to get these slides. Everybody here is going to get these slides tomorrow. All right. Okay. So I think we'll take some questions.
I don't have any questions right now in the Q&A.
Wow.
You did a great job of explaining special needs trusts and ABLE accounts, Jason.
All right. All right. Any questions, guys? Yeah, I'll stay here as long as we need to make sure everybody gets.
There's one.
Laura.
Oh. Can we put up our contact information again? I will
Yes.
type that in for you. How's that? Oops, let me do that in the chat instead.
Yeah, I can actually just share it. Now I can't share it.
Done. Okay. Oh, good. You got it. couldn't get into the chat.
All right. No questions? So I either explained it really well or really poorly, one of those two.
Well, if we have a lot of calls tomorrow about special needs trust, Jason. Oh, here's some more coming in. Let's see.
I believe Laura Kelly had a question.
Yeah, Laura, we can't hear you.
Yeah. Okay, so there are some coming. Are you putting your question, Laura, in the Q&A? I'm going to start with some questions that are in the Q&A right now.
Sounds good.
I've heard of individuals being denied access to their trust funds. Is this a common issue?
That's super broad. I mean, there's really no way to deny an individual. I mean, the trustee's obligation is to support an individual with their needs. Now, if someone has $100,000 in their trust and they ask for a Maserati, the answer is probably no. So, I mean, the trustee has to ask, has to operate. Their objective is to, one, ensure that that person has their needs met, and two, make sure that the money is spent in a way that maximizes the amount of time that it can be there. So I'm not sure what that experience would be to deny someone access to their trust fund. Like they're denied direct access to their trust fund because that's what keeps those benefits intact. If that's what the question is. I mean, an individual can't just walk into a bank and, take out money, because what happens is if you give an individual who has a trust any cash out of it, it actually counts as income, which could actually blow up their benefits a different way, because you have, the asset test and then you have the income side. So an individual might get effectively become ineligible for benefits because you've given them, like, you can't give somebody like $2,000 cash out of the trust, because now you just gave them $2,000 worth of income on top of their other income. So you can invalidate trust that way.
Okay. Should I go to Plan New Jersey before I go to see a lawyer? I think I've consulted lawyers for the information you're sharing tonight.
You can. I'm happy to talk to everybody. So, we'll spend time talking, and if you want to call us and just see if there's anything you're missing, I can certainly probably help streamline your questions, minimize attorney clock hours, so you at least know the right questions to ask, and go in there knowing what product you need. So I'm happy to do that.
Okay. What is the best order to proceed in if I am in the process of setting up trust, successor guardianship, etc.?
Trust always first. Setting up the trust, because it's one of those things that you want to make sure a trust is in place, because you can't do anything about that after the fact. So I always say start there. Once you have that piece situated, that and your will, the guardianship and any other planning can be subordinate to that. But the trust is the one thing that if you pass away before a trust is completed, the only option for Tom is to put that money into a first party trust, which now has a lien and then impacts your potential remainderers.
Okay. Let's see. If an individual with a disability has a retirement account, can that be converted to a first party trust? And the same for their parents' retirement account. Can that be paid into a third party trust? So 2 questions there.
I think you end up with some tax consequences, but I believe so. That's a financial planner lawyer question. I'm just not comfortable answering that because I don't know what the holdings are, and I don't want to give you bad information. So, that's something that you'd want to speak to someone who's more familiar with your holdings, what you have, what your plan is, and then give you the most advantageous financial and tax information.
Okay. Let's see. Okay, this is regarding special needs trust. Who is the asset manager? Who or what owns Plan New Jersey? And
Okay.
then there's a third question. What are fees to manage a special needs trust?
Okay, so first question. Well, no one owns Plan New Jersey. We're a private nonprofit organization, so we're not owned by either shareholders or a person or entity. We have a board of directors that oversees our executive director, who oversees myself and our trust director, who oversees the rest of the staff at Plan New Jersey. So we are a traditional nonprofit. Our board of directors, excellent group of folks, and they're vested in it. Our bylaws and really, in essence, it's more than that. At this point, that more than 50% of the board have to have some connection to the disability community, meaning that they have a child or a sibling or whatever the case may be. So that's who oversees us, helps us set our culture, make sure that we're staying true to our mission. They're parents much like everybody else, right? The other question of what was the other one? Not the trust fees. I'll answer that at the end. What was the other one?
Who is the asset manager?
So the asset manager, it could be either, I know that we utilize Merrill Lynch. So, a lot of our assets are held with Merrill Lynch, some with BlackRock. I think that's about it. That's who's, I think some with PNC as well, maybe. So there might be, so I think there's about 3 different asset managers holding different amounts, but I'd say the bulk of our investments are held with Merrill Lynch. Trust fees are one of 2 numbers. It's either $1,800 per year or the statutory rate, which is 0.5% of the principal plus 6% of the income. When you do the back of the envelope math, most trusts, it still comes out to being in and around that $1,800 region. So it's whichever number is higher. So an example would be that on a year like 2022, 2023, it's going to be $1,800 because, the financial world is absolutely miserable right now. Everything is down. No one knows when it's going to go back up again. When there are gains in it, you'd probably revert to that statutory rate, which is the 0.5% of the principal plus 6% of the income. And then it's a progressive system. So that's up to 400,000. And then that amount of the principal changes when you get above that. If you're above that, I can certainly give you better information when we speak. But it goes down because you're talking about larger numbers. So you're not going to take that much of the principal.
Okay. A semantics question. I've been told that if your special needs trust is called a supplemental needs trust instead of a special needs trust, Medicaid will not recognize it.
I haven't heard that specifically, but it brings up another important point of making sure that your trust conforms with Medicaid language. So if you wrote a trust many years ago, it probably makes sense to go back in and speak with your attorney when you go to update your will or for some other purpose, to have them take a peek at the trust, make sure it's conforming with current Medicaid language. Even if it's written by a reputable attorney, there may be some updates to what language Medicaid does or does not want. More importantly, that when you're doing these trusts, you don't want to go to, a generalist attorney. You specifically want to stick in the realm of estate planning attorneys that deal with these kinds of things. Because what happens is if you write a trust that does not conform to Medicaid, what Medicaid wants language-wise, they're going to send that trust back. They're not going to invalidate it, and they're not going to say you can't use it. They're going to say that it has to be rewritten to conform with their language, which means that if you saved some money on the front end by someone who wasn't an expert that wrote the trust, you're still going to have to pay for it on the back end, again, to have somebody rewrite the trust. So you don't want to pay $3,000 or $4,000 twice. So you want to make sure that whoever you're taking it to has expertise in the area of writing special needs trusts. And the reality is they'll name it whatever the convention is that's appropriate. So that part doesn't even matter because your attorney is going to name it whatever the nomenclature has to be for its conformity with Medicaid.
Okay. And when you set up a plan with Plan New Jersey now for the future, how is a relationship established with Plan New Jersey and your child before a parent passes?
Sure.
So that child is comfortable with Plan New Jersey and their staff before they really would need them.
Sure. So it depends. I mean, a lot of families will write a life plan, and depending on the age of that individual when they write it, maybe we just are an afterthought for a while. So we have families that we'll write a plan with. Maybe their child is in their 30s or 40s. There's really no part for us to play. Parents are still young, child is still young. There's not really a way for us to establish a lifetime of a relationship at really a reasonable cost. you know, we're talking about services when you're not here. So the objective is not to, start servicing you now. It just doesn't make much sense to do that. What I typically tell folks is one, I mean, once you're going to have access to my cell phone. So, just having a chat with me every once in a while, if you're just wondering what's going on at Plan New Jersey, you join our mailing list so you can kind of keep up to date with changes. If we have any change in management personnel or anything like that. Really, when the child is young, it's really more of like a social insurance policy, if you will, right? So, there's plenty of time for us to get to know. It's just you want to do it at the right time. We don't want to create a situation where we're visiting and eroding and sending invoices, and not having a real important job to do, because it's duplicative of what you're doing. So, for the most part, the families that we write life plans for, there's usually a period of time where we're not really doing any services for them. When things come up, maybe somebody gets bad news at the doctor, that's usually the time when we will typically engage, and maybe it's on a limited basis. And when you guys are here, we can ultimately just kind of do things at your will. You drive the life plan. If you want us to come and visit, I typically tell parents that want us to be involved on some level, invite us to the ISP, because that's where we get to meet all the people involved in your child's life, all of the care providers. It's probably the most value for a once a year meeting. If we were to participate in that, that's usually the best way to kind of make sure that we know, okay, who's the support coordinator, who's the day program manager, who's the residential manager, whatever the case may be.
And Jason, we also will update those life plans kind of in perpetuity. So as changes occur, from the time the plan was written, you can always contact us to let us know what those changes might be.
Correct.
And this is a very good question. And it's, are you allowed to show your child a copy of your life of the life plan and or collaborate with your child on it?
You absolutely are able to. I think that depends on your child and why you're writing the life plan and what content you expect to be in there, right? So a life plan is not a mean-spirited document, but it's a factual document. So normally when we start them, remember that your child is the person we're serving, but we're also serving you as well, right? You're transferring your information to me. So it's not necessarily all the rosy happy moments either. It's also some of the information that I just need to know, so this way I can better serve your child. So depending on what information you give me, you may or may not want to share that with your child. So I mean that's ultimately up to you. When we write a life plan, it's not our proprietary document. When we write a life plan, we write them for you. So you get the document and you can do as you please with it. We keep a copy of it in our files and, saved permanently. But you can share that with other care providers. You can share that with other family members. You just want to be careful because it's written in a candid way. It's really because I'm going to ask you questions like what an example of a question would be, what are this person's triggers and symptoms? What are things like on a bad day? What does a bad day look like? So I can better support that person. So if you don't want your child to see the answer to that question, you may not want to share that document. Because we've had experience where individuals have come across a copy of it and they weren't pleased because it's effectively their parent kind of giving, private information about, their situation and they didn't take it. And then other families, the individual is with us writing the life plan all along. So it's really not up for me to decide that.
Okay, I do not have any other questions, but I have a lot of thank yous.
Okay. All right, folks. All right, folks. It was absolutely my pleasure being here. And like I said, it's a real offer. So if you guys want to do a little bit more direct, specific planning to your situation, just give us a call and we'll talk and, you know, make sure that you're as well planned as you possibly can be. Okay.
Wonderful. Thank you so much for your time this evening. This was a really informative and wonderful presentation. As always, Plan NJ provides tremendous resources for our families, and we so appreciate your time and sharing your expertise with us this evening. Just a quick reminder, please complete the survey. There's a link to it in the chat. Let us know what you thought about tonight's presentation, the good stuff, and maybe the stuff we need to improve on. Any feedback is incredibly helpful and will help shape future programming. So thank you so much for your time, and we will get these materials out to you tomorrow. Thank you so much, everyone, and have a wonderful evening.
Thank you, folks.
Thanks. Good night.
Good night.